Okay, folks, welcome to Chapter 4, Freehold Covenants. Very, very important and tested in exams, especially with reference to what is the difference between freehold covenants and easement. So, freehold covenants, they allow landowner to control how neighboring land is used, preserve residential character, maintain property values, or create uniform development standards across state. For example, you can't have cats on this property, or you cannot park your caravans on your driveway at that point. So these can be restrictive. You got the land, but there is a promise you give it that you will not use land in certain way, or you will do certain things in that one. So that is positive and negative covenants. We will be talking about them. So let's start with the fundamentals. A covenant is a contractual promise about land made by deed. Covenant obligates parties either to do something or to refrain from doing something. They create benefits for one party and burden for another party. And crucially, these benefits and burdens may affect not just the original parties, but also their successor in title, mean whosoever buys this land. Covenants commonly arise when land is subdivided. Imagine a developer who owns a large estate and sells off individual plots for house building, for example. The developer wants to ensure estate maintains certain standards. As I said, you cannot park, the caravans at that point. So understanding terminology is essential. Covenanter is the party making the promise, the person who agrees to be bound by the obligation, and covenantee is the party receiving the benefit, the person who can enforce the promise at that point. And we can borrow terminology from easement, servient tenement, the property that is burdened by the covenant. Servient means serving, and dominant is the one which is getting benefit from other property or other land at that point. So restrictive versus positive, or we call it negative kind of. So most important classification, this distinction determines whether burden can bind successor, and it's absolutely it's very essential to understand in terms of deciding will it go with the land or not. So restrictive covenant are negative in substance. They prohibit or restrict the covenanter from doing something. On the servient land, for example, crucially, they do not require the covenanter to spend money or take positive action. Example include covenant not to use land for commercial purpose, not to build above a certain height, not to keep animals, not to erect fences, not to alter something like, in certain way. So the key characteristic is that compliance costs nothing. You comply simply by refraining from prohibited activity. Restrictive covenant can bind successor in title under the rule in Tolk versus Moxey. We will talk about it. So positive covenants require covenanter to do something, spend money on something. Like, for example, covenant to maintain fences, paint fences, boundaries, to repair buildings, pay insurance premiums, to contribute to maintenance of common areas. For example, there is a swimming pool and all of you will be paying for it, or to keep property in good repair and all of it. So the defining characteristic is that compliance requires expenditure of money or effort. You must actively do something to comply. So the landmark case is Stephens in 1994. The House of Lords confirmed that the burden of positive covenant does not run with freehold land at common law or in equity. Only the original covenanter remains liable. This creates significant practical problem for positive covenants, which we shall discuss in detail. Why the distinction? Because the law is reluctant to impose ongoing financial burden on successor who may not have agreed to them and who receive no corresponding benefit when they purchase the land. So we'll talk about it in detail about modern covenants and all. So what is the difference between covenant and easement? So we often confuse covenant and easement because both create rights and obligation between neighboring landowner. So let's clarify. Covenants are promises about land. They are inherently contractual, arising from agreement between parties. They create equitable interest in land. They must be created by deed. They are no equivalent to easement by prescription or implication. Easement are rights to use land. They are proprietary rights that may be legal or equitable. They can arise not just by deed but also by prescription through long use or by implication when land is divided. Here is a practical example that frequently causes confusion. A covenant requiring a landowner to maintain a fence or boundary is a positive covenant. It requires expenditure and does not bind successor. It's not an easement because it does not give anyone a right to use the servient land. It merely requires the servient owner to maintain something on their own land. The case of, we got sorry, I could not pronounce it. I would say it headache. Case in 2019 that confirms a so-called fencing easement requires a landowner to maintain a fence was actually a positive covenant, not an easement. As a positive covenant, it did not bind successor, mean whosoever buys the land. So this distinction is crucial in SQE. You need to understand the difference between easement to maintain and restrictive covenant. At that point, you need to understand what is the difference between the two. So, creation of covenant, how they are created. The standard method is to include covenant in the deed once the property is transferred. When a seller transfers land to a buyer, the transfer deed contains covenants that the buyer agrees to observe. This is the clearest and most common method. The buyer signs the deed, explicitly agreeing to the covenant. The alternative method is a separate deed of covenant. This is used when covenants need to be imposed after land has already been transferred, or when multiple landowners want to create mutual covenant between them or among them. The covenanter signs a deed containing the covenant terms. In registered land, a notice must be entered on the register to protect the covenant. So, regardless of method, proper formalities are essential. A covenant must be made by deed to create a legal interest. Without a deed, you might have a contract to create a covenant, which could be enforceable in equity between the original parties, but it won't have the same effect as covenant. For registered land, protection is critical. The covenant should be registered as a notice in the charges register of the servient land. In the servient land, that's what we need to keep in mind. This ensures the covenant appears on searches and binds subsequent purchaser. Once they are purchasing land, of course, they will run searches and they will find it. For unregistered land, restrictive covenant must be registered as Class D2 land charges against the name of the estate owner. At the time of creation, failure to register render the covenant void against a purchaser for money or money's worth, even if the purchaser had actual notice. We have talked about it many times. So what is registration requirement for restrictive covenant and how to ensure enforceability? So let's talk about registration in more detail, because the rules differ depending on when the covenant was created and whether land is registered or unregistered. So before 1926, restrictive covenants were documented in title deed but were not subject to any registration system. The burden bound successor only if the purchaser had actual constructive or implied notice of the covenant. This created uncertainty because purchaser might not discover covenant until after purchase. The Law of Property Act 1925 fundamentally changed this for unregistered land. From 1926 onward, restrictive covenants affecting unregistered land must be registered as Class D2 land charges. In the land charges register, registration is against the name of estate owner time the covenant was created, not against the property itself. If property is registered, the covenant binds all subsequent purchaser regardless of notice. If not registered, it's void against purchaser for money or money's worth under Section 4 of the Land Charges Act 1972. Actual knowledge is irrelevant. The mechanical rule of registration applies. For registered land, restrictive covenant should be protected by entry of a notice in charges register of the servient land's title. So this is against land title. Once entered, the notice gives priority against subsequent purchaser. The covenant appears on official searches, giving purchaser clear notice. If a restrictive covenant affecting registered land is not protected by notice, it may still bind if it qualifies as an overriding interest. But this is rare and uncertain. The safe course is always register it as a notice. So, identifying beneficiaries, a practical problem that frequently arises in identifying who has the benefit of covenant and can enforce it. This is very difficult with older covenant affecting multiple properties at that point. In unregistered land, you must examine the title deed to trace the covenant's history. Pre-contract inquiries should ask the seller to identify anyone who might have the benefit, but this process is often uncertain, specifically when land has changed hands many times or been further subdivided. In registered land, the position should be clearer. You examine the property register of the potential dominant land to see whether the benefit is noted. But entries are not always complete or accurate, particularly for older covenant that predate registration. So, pre-contract inquiries are essential in both systems. The buyer should ask the seller whether any covenant benefit the seller land, whether any covenant burden the property being sold, and whether the seller knows of any breaches. When beneficiaries cannot clearly identified, or when there is uncertainty about whether a covenant has been breached, indemnity insurance provides protection, and that's the best thing. The buyer can obtain insurance against the risk that an unknown beneficiary later emerges and seeks to enforce the covenant. This is common practice when dealing with older covenants or where title is unclear. So for SQE1, remember that inability to identify beneficiaries does not make covenant unenforceable in principle. It merely creates practical difficulties. If a beneficiary later emerges and can prove entitlement to benefit, they can enforce the covenant regardless of whether they were identified earlier or not. And the solution, of course, by indemnity insurance. So who can enforce it? So original parties can always enforce covenants between themselves based on privity of contract. If A covenants with B not to use land for commercial purposes, B can sue A for breach of A's violations of the covenant. This is simple contract law. The covenant is a contractual promise and contract binds the parties who made them. Now, but what happens when the land changes hand? If A sells the servient land to C, can B still enforce the covenant against C? If B sells the dominant land to D, can D enforce the covenant against A or against C? These questions involve whether the burden of covenant runs with the servient land to bind successor and whether the benefit runs with the dominant land to entitle successor to enforce. So the answer depends on whether we are looking at common law rules or equitable rules, whether the covenant is positive or restrictive, and whether various technical requirements are satisfied. Equitable principle may allow successor to enforce covenant even though they were not parties to original agreement, but equity's intervention is limited and subject to strict requirement. Understanding these rules is the heart of covenant law, and let's talk about it. So common law rule. Say, let's talk about transfer at common law, burden and benefit. At common law, the burden of covenant cannot run with freehold land. This is the rule from a case law. I call it Oldham Case Law Corporation of Oldham Case Law. It confirmed in Stevens' case, no matter whether the covenant is positive or restrictive, the burden remains with the original covenanter, the one who covenanted. That was the case. This means if A covenants with B not to use land commercially and A sells to C, C is not bound by the covenant at common law. B can still sue A for breach if C violates the covenant, because A remains liable under privity of contract, but B cannot sue C directly at common law because the burden has not passed to C. Simple rule of privity of contract. This rule creates obvious problem like in land. The original covenanter may be impossible to locate, may have no asset, or may have died. Enforcing against someone who no longer owns or controls the land is often impractical. To solve this, the benefit of covenant, however, can run at common law if these requirements are satisfied. First, the covenant must touch and concern the dominant land, mean it benefits the dominant land. The test from Swift in 1989 requires that covenant benefits the dominant land itself, not merely the covenantee personally. So it is not personal benefit, it benefits the land. So it must affect the nature, quality, or value of the land or the mode of using it. Burden will not transfer, and benefit, if it benefits the land, will transfer. Second, the original parties must have intended the benefit to pass to the successor. This intention is usually presumed from the nature of the covenant. Third, the successor claiming the benefit must hold a legal estate in the dominant land. If these requirements are met, the benefit passes automatically to successor of the dominant land at common law. This means if B sells the dominant land to D, D can sue A for breach of covenant even though D was not party to original agreement. Alternatively, the benefit can be expressly assigned under Section 136 of Law of Property Act 1925. The assignment must be in writing, and written notice must be given to the covenanter. This creates a direct contractual relationship between assignee and covenanter. So from that person, it is assigned and covenanter gets it. But remember, even if the benefit had passed, if the burden has not passed, the only person who can be sued is the original covenanter. This is why common law rules are inadequate for restrictive covenant. Now let's talk about equity if common law is inadequate. Equity developed different rules to address the inadequacy of common law, particularly for restrictive covenant. The landmark case of Tulk versus Moxey in 1848. In equity, the burden of restrictive covenant can run with land if 5 requirements are satisfied. This is fundamental. Learn these 5 requirements. This is the way burden will transfer. Otherwise, common law will apply, burden will not transfer. First, the covenant must be negative or restrictive in substance. Remember our earlier discussion, it must not require expenditure of money. This requirement is absolute. Positive covenant cannot have their burden pass in equity. Second, the covenant must benefit identifiable dominant land. This is similar to easement, like you can identify the land. There are 2 lands and you can identify who is getting benefit and who is giving benefit. Third, the covenant must touch and concern the dominant land. It must enhance the dominant land's value, amenity, not merely benefit the covenantee personally. It's not kind of personal promise benefit that you will come and give me massage or you will just mow my lawn. Not at all. It is something which is connected to land. Fourth, the original parties must have intended the burden to run. Section 76 of Law of Property Act 1925 provides that covenants relating to land are deemed to be made by the covenanter on behalf of a successor in title unless a contrary intention appears. This creates a presumption of intention. Fifth, the last one, the purchaser of servient land must have had notice of the covenant. In modern registered land, this means the covenant must be registered as a notice or qualify as an overriding interest. In unregistered land, created after 1925, it must be registered as a Class D2 land chart. So if all 5 requirements are satisfied, equity treats the burden as binding the servient land itself, not just the original covenanter. The grant owner of servient land can be sued directly for breach even though they were not party to original covenant. So there is one important exception to the rule that positive covenant don't bind successor, the doctrine of mutual benefit and burden from wholesale case, and that provides if a successor takes the benefit of covenant, they must also accept associated burdens, even if positive. This applies particularly in development with shared amenities where owner benefit from communal facilities and must contribute to their maintenance. For example, a common gym or something, swimming pool they are using together. Okay, how successor enforce, so that's very important to understand. The first method is annexation, attaching the benefit permanently to the dominant land so it passes automatically with every transfer. Section 78 subsection 1 of Law of Property Act 1925 provides that a covenant relating to any land of the covenantee is deemed to be made with the covenantee and their successor in title. This creates statutory annexation unless excluded by express contrary intention. For annexation to work, the covenant must clearly identify the dominant land and it is intended to benefit, for example. So land and the benefit intended. Vague references are not sufficient. The covenant must be framed so that it's clear which land benefits. Annexation is the simplest method because once achieved, the benefit passes automatically with every transfer of dominant land. No express assignment is needed. Any successor who owns the dominant land can enforce the covenant. The second method is through a chain of equitable assignment. Each time the dominant land is transferred, the benefit of covenant must be expressly assigned to purchaser. This required careful documentation. So if a transfer occurs without express assignment of benefit, the chain is broken and subsequent purchaser cannot enforce the covenant. The third method involves building scheme, also called scheme of development. These arise where land is divided into plots sold subject to uniform covenants. The example I have given you, not to park caravan on your parking. So there is a case law that way, Ellison versus Reacher in 1908, and requirements are very strict. First, the land must be divided into clearly defined plots. Second, the covenant must be imposed for common benefit. Third, the original purchaser must have bought on the understanding that covenant would be mutually enforceable at that point. So in terms of societies, as I am talking, don't park your caravan or do something at that point. So safeguards, protection for covenanters. The first protection is indemnity covenant. So when selling land subject to covenants, the seller should require the buyer to covenant to indemnify the seller against future breaches. If the buyer later breaches a covenant and the original covenantee sues the seller as the original covenanter, the seller can recover from the buyer under indemnity. These indemnity covenants should continue down the chain, each successive person should take indemnity. For registered land, compulsory renewed covenant provides additional protection when transferring land subject to covenant. The transfer can include a restriction on the register requiring every future buyer to enter a fresh covenant with the original covenantee. This creates direct contractual liability. State rent charges offer another mechanism, particularly for positive covenants, and state rent charge is a periodic payment charge on land. If the landowner fails to perform required positive obligation like maintenance, the rent charge holder can enter the land and perform the work, recovering costs through the rent charge. This provides a way to enforce positive obligation against successor even though the covenant burden does not run. So these protective mechanisms are important to understand for your SQE exam. So what are enforcement options and what are remedies? That's what we will try to learn. So once again, so we will try to learn the remedies. For restrictive covenant and primary remedies and injunction, a court order requiring the defendant to stop breach or refrain from future breaches. Injunction are equitable remedies granted at the court's discretion. Court orders, injunctions, and they consider various factors when deciding whether to grant injunction or not. Has there been delay in seeking relief? Has the breach been tolerated in the past? Would an injunction cause disappropriate hardship compared to the benefit to the claimant and all? If an injunction is refused, damages may be awarded. So once damages are not adequate, at that point injunction is awarded. So for positive covenants, enforcement is limited to original covenanter because the burden does not run. If you can identify and sue the original covenanter, remedies may include specific performance and order requiring them to perform the covenant, such as carrying out repairs or damage or breach of paying for the breach of contract. But remember the practical limitation: the original covenanter may no longer own, control the burdened land. So ordering them to perform work on the land they don't own is often impossible at some point. So, ending of covenant. It can be ended by consent, that parties they consent. It can be ended by implied extinguishment, long-term non-enforcement. It can be taken off by upper tribunal, land chamber, that it has gone obsolete, no one uses it. And of course, indemnity insurance that protects buyers. Our exam tips, that is my favorite slide always. First and most critical, identify whether each covenant is positive or restrictive. Don't rely solely on the wording, analyze the substance. A covenant not to allow premises to fall into despair sounds negative, but is actually positive because compliance requires expenditure on repair. So keep in mind this appears in exam. A covenant to maintain in good repair is clearly positive, but a covenant not to use for commercial purposes is genuinely restrictive. So distinction is absolutely fundamental because it determines whether the burden can run. If the covenant is positive, burden cannot run at common law or in equity. Only the original covenanter remains liable. If it is restrictive, the burden can run if equity under Tulk versus Mogsay, the requirements are met. Second, work through the requirements systematically for burden to run in equity. Negative covenants benefit identifiable land, touch and concern the land intended to run, and notice to purchaser all of it, otherwise it will not. For benefit to run, has an accession occurred through section 78. If there is chain of express assignment, does a building scheme exist? So all of it, check it. Third, always check registration requirement. It is a common trap. Even if all substantive requirements for burden to run are satisfied, if the covenant isn't properly registered, it won't bind a purchaser for value in modern land law. In registered land, look for a notice in the charges register. In unregistered land, created after 1925, check whether it was registered as Class T2 land charge. If registration is missing, the covenant is void against purchaser for money or money's value. Fourth, consider both common law and equitable rules. Don't focus exclusively on equity just because that's where the interesting rules are. Remember at common law, burden cannot run, but benefit can run if requirements are satisfied. In questions involving enforcement by successor of dominant land against the original covenanter, common law rules may provide the answer. Fifth, watch for building schemes. These are popular in exam and all, a Liston versus Reacher requirement. You need to keep in mind, is it mutual? And once it is mutual, once you are getting benefit, you need to perform or you need to hold the burden as well. Don't forget, sixth point is don't forget about indemnity covenant and protective mechanism. When problem question involve transfer of servient land, consider whether indemnity covenant protect the seller. So that's what is very, very important. Another thing, be precise about parties, identifying clearly who is seeking to enforce against whom. Is it original covenantee against the original covenanter, successor of dominant land against the original covenanter, so and so. And also, the House of Lords decision confirmed that positive covenants cannot have their burden run with freehold land. It's cited constantly and represents settled law. Don't suggest that positive covenant burdens might bind successor. They don't, and House of Lords has definitely rejected reform argument, kind of. And also, another thing, covenant exists to protect land value and control development. When analyzing whether covenants touch and concern land, think practically about whether they benefit the land itself or they are only personal. So all of it are exam tips. I hope it helps you. I hope you master these rules, and I wish you all the best. If you like our sessions, I would request hit the subscribe button and share it with your friends. Thank you. Ta-da.